All right. Well, welcome to our Wednesday Zoom and Learn. My co-host Annie Taylor is taking care of her puppy at the vet right now, so not able to join us, but she may jump on a little bit later. And today we are talking title. We're going to discuss the 5 ways of holding title. I know you guys get this question a lot from your clients when escrow may ask them, how do you want to hold title? And they don't know quite what that means. So therefore they will reach out to you for guidance. So I am also going to post the document that I'm going to go over in the chat, and you can download it in the chat. If you're unable to, reach out to Annie or I, and we will email it to you. It's a good cheat sheet to have because it really breaks it down on all levels and lets you know. So sorry about that. So let me go ahead and bring that document up real quick, and we'll get started talking about this. All right, so let me move that over. So concurrent co-ownership interests, different ways of holding title. The 5 ways of holding title are community property, joint tenancy, community property with rights of survivorship, which would be probably the most common for a married couple, tenancy in common, and tenancy in partnership. Tenancy in partnership, you're going to see less than you're going to see all the other 4, but we're going to explain all of them. And what I'm going to do is we're just going to kind of go in order of each one instead of kind of jumping between the 2 so that you don't get confused. But again, this is a great cheat sheet for you to have on hand, because sometimes it is difficult to remember all the facts that pertain to each one, right? So the first one is community property, right? This can only be held by husband and wife or domestic partners, okay? Usually you'll see community property with rights of survivorship. However, community property is a common one as well, because there are many different factors that may play a part. If it's not their first marriage, say it's their second or third marriage, and they may have multiple kids from different marriages, they may choose to do community property where they each own a separate right as community. The biggest thing in that to remember is the word community, okay? So right here, each interest is separate, but management is unified, okay? So when you go through, it's divided ownership and managerial interest in the property are equal, except control of business is solely with managing spouse or partner. The biggest thing to remember in all this is, again, community. Both co-owners have equal management and control, which means they own equal rights, not 20% and 80%. They own equal. Personal property, except necessaries, may be conveyed for valuable consideration without consent of other spouse or partner. They're in it together, right, as community. So you're not in it as partners, you're in it as community. Purchaser can only acquire whole title of community, cannot acquire a part of it. So as community property, if I owned a property with somebody else in community property, I can't just sell my side, my rights to it, right? It has to go as a whole. On co-owner's death, half belongs to survivor in severity, half goes by will. So it's very important to understand that community property owned by 2 people, if one were to pass away, the remaining rights of the property jointly as community property does not revert to the other person on title. Meaning, if I own community property with, say, a spouse that had kids from a previous marriage or what have you, and she passed away, her rights to the property can be willed to the kids. It doesn't automatically revert to me, okay? If you're passing it by will, tenancy in common between devisee and survivor results, which means if she were to will her rights to the property to her daughter, now her daughter and myself have community property, okay? Close that, please. Creditor rights, this is important as well. Property of community is liable for contracts of either spouse or partner which are made after marriage and prior to or after marriage. So if you get married and you guys buy a house and you have it as community property and there is a creditor that comes after one of the spouses, they can go after that portion of the house, right? So there is an act that was passed in regards to all this that you can refer to and stuff. This is a one-off because every situation is different. So I'm not going to go into detail of how that will take place because it depends on the situation. And then presumption, strong presumption that property acquired by husband and wife or domestic partners is community property. So again, community property, you see it more with partners than you do spouses. Typically with spouses, you're going to see with rights of survivorship, and we'll talk to that in a minute. Matter of fact, we'll go to that one right now. So community property with rights of survivorship. It's between husband and wife or domestic partners. Ownership interest is equal. Title is, again, in the community between the two. Each interest is separate. Both owners have equal possession, and real property requires, sorry, people are coming in. Real property requires written consent of the other spouse or partner with separate interests, cannot be conveyed except upon death. So you can't convey it to somebody else except for at death. It would have to be completely redeeded, okay? On co-owner's death, the entire tenancy remains in the survivor. So the right of survivorship is one of the primary incidents of community property with rights of survivorship. So again, that's why it's most common with spouses, is it's equal ownership rights, and if one were to pass, the remaining reverts to the other spouse, okay? Property of community and liability of contracts of either spouse or partner which is made after the marriage and prior to after January 1st, 1975, co-owner's interest can note be sold separately. Whole property may be sold on execution to satisfy a creditor. What that means is the portion of the property that one may own can be sold, and at that point, the creditor becomes to fulfill a credit obligation, and at that point, the creditor becomes the other a partner within that that title. Okay, you don't see that too often. Creditors want their money; they don't want to be part of a title on a property. Joint tenancy, I would probably say, is the most common. And the reason why is two or more persons it may be spouses or domestic partners, but it has to be two or more persons can own as joint tenants. Joint tenancy ownership interest is equal. There is only one title to the whole property, and it cannot be willed, which means two or more people own that property. If one were to pass away, 100% of the rights revert to the remaining person on title. There could be 3 people on title. If one passes away, the other 2 acquire the ownership interest of the one that passed away. As joint tenancy, it cannot be willed, okay? So that is how people will hold title if it's a notion of holding the property when they know they're not going to will it to a family member or something like that on one side or the other, right? Conveyance by one co-owner without the others breaks its joint tenancy. So if one partner wants out of ownership or wants to be bought out or what have you, and that takes place, joint tenancy is broken and title will need to be held in a different fashion, okay? The purchaser will become a tenant in common with the other co-owners in the property. So let's say that 2 people own a property and they want to sell 50% of the rights to that property to somebody else or bring a third partner on. They can do that. However, on title, it would be held the 2 people as joint tenancy and the 1 as tenants in common, all on the same deed, okay? Upon a co-owner's death, his interest ends and cannot be deposited or deposed of by will. So survivor owns the property by survivorship. So Betsy and I own a property, I pass away, 100% of the rights to that property reverts to Betsy, okay? And that is the most common because in all other incidents pertaining to holding title here, if one were to pass away, then potentially that could cause a probate or a minimal probate, okay? A minor probate. With joint tenancy, it would not. It would 100% revert to the other owners or owner on title as joint tenants. So therefore would not cause a probate issue, okay? Co-owner's interest may be sold on execution sale to satisfy a creditor. Joint tenancy is broken, creditor becomes tenant in common. So again, if you sell your interest to a creditor and the creditor becomes on title as a co-owner, joint tenancy is broken and it reverts to tenants in common. And it must be expressly stated, not favored. So you cannot favor one side or the other in the ownership of the property. It would have to be expressly stated specifically for it to revert from anything other than common property owned together with same rights. So tenants in common or tenancy in common, a lot of times they call it tenants in common. This is 2 or more persons, maybe spouse or domestic partner. Ownership can be divided into any number of interests. So this is typically used when you have multiple owners with different ownership levels, right? So let's say Betsy and I and Colleen go in to buy a house and I own 25% and Betsy owns 30%, or I own 20% and Betsy owns 30% and Colleen owns 50%, right? We would be tenants in common and it would be specifically stated on there that on the deed that we each are tenants in common, and it would specifically state the percentage of ownership rights that we each have, okay? Each co-owner has a separate legal title to his undivided interest. Sometimes you'll see it on one deed where it's broken down. Betsy owns 20%, Tommy owns 30%, Colleen owns 50% as tenants in common. Sometimes it'll just state Betsy Berkey owns 50% ownership rights as tenants in common. And she has one deed, and then there's a separate deed that I own that says I own 30%. And they're all recorded as separate. So you can see it either way. Possession is we all have equal rights to possession. Conveyance, each co-owner's interest may be conveyed separately by its owner. So if I own 30% of that property, I can sell my 30%. Okay, so I have the rights to that 30%. I can sell my 30% and somebody else will then become owner of that 30% and tenants in common with the other two. Okay. Purchaser will become a tenant in common with the other co-owners in the property, which we just stated there. Upon deaths, on co-owner's death, his interest passes by will. So to his devisees or his heirs, no survivorship rights. So I pass away, my 30% that I own on that property, it could be willed to my daughter or anybody that I state. However, if it is not in a trust, that 30% would need to go through probate to transfer. Okay. And not only that is, let's say that, because I've had this happen a handful of times. Let's say there's two people on title. One owns 30%, one owns 70%. The one that owns 30% passes away. They don't do anything with title. 5 years down the road, the one that owns 70% decides they want to sell the property. They can't sell the property at that point because there's a cloud on title. We have a tenant in common that passed away, and that person did not have a will or did not have a trust stating what would happen with this 30% rights on that property. Therefore, it goes through a minor probate. And it has to go through a probate to find out if there's any next of kins, et cetera, and who has rights to that 30%. So it becomes a little bit clouded, it becomes a little bit messy at that point. And I have one that we're dealing with actually as we speak that is exactly that kind of. Co-owner interest may be sold on execution sale to satisfy his creditor. Creditor becomes tenants in common. So same thing as the past ones. I can sell my 30% to the creditor to fulfill a credit obligation, and then that creditor becomes the owner of that 30% as tenants in common with the others. Okay. Let's talk tenancy and partnership. Usually see this again, keyword partnership. Only partners in any number. It could be 2, it could be 8, it could be 20. Okay. Ownership interest is in relationship or in relation to interest in the partnership. So we form a partnership, and my interest in the property that is owned is based on my interest in the partnership. Okay. Title is in the partnership. And we have equal right of possession, but only for partnership purposes. And so it's typically that when you form a partnership, it would have stipulations in there that specify certain things, right? For conveyance, any authorized partner may convey whole partnership property. No partner may sell his interest in the partnership without consent of his partners. So again, at this point, the partnership owns title on the property, and the rights of each partner within that partnership is based on the partnership, not based on what is written in title. Okay. Purchasers can only acquire the whole title. So again, the partnership acquires title as a whole, not as a percentage. So when you have a partnership and Betsy wants to be part of that purchase on that title, if she's not part of the partnership, she can't have title rights to that title. It's held in the partnership rights. She would have to be part of that partnership. Okay. You have the rights in partnership interests, but not in the specific property. So successor status. I'm a partner and I own 10%, and we own a house, and it's in the partnership name, and I pass away. My next of kin has rights to my 10% in the partnership, but not in the specific property. Does that make sense? And if you guys have questions, just unmute and pop in. Partner's interest cannot be seized, sold separately by its personal creditor, but his shares of profits may be obtained by a personal creditor. Whole property may be sold on execution sale to satisfy partnership creditors. So again, the property itself cannot be used to satisfy a creditor debt unless the entire partnership was the partnership's debt and they all agreed to utilize that asset in that manner. So these are the 5 different ways of holding title. Of course, there are a couple other ways, right? Because you have to specify as an individual when you hold title of how you want to hold it. Well, you have to specify one of these. Once you specify these, then you have the rights to that property. When it closes, you have the rights to then roll it into, say, a trust, and a trust can hold title. But at that point, the trust also dictates the rights of the property. So if something were to happen to myself and I have a family trust, I'm dictating within the trust what will take place with that property. It'll be split across 3 children. It'll be left to my surviving spouse, and in turn of her death, will be left equally amongst the children. I can specify in the trust that the property can never be sold, never be refinanced if it was fully paid off, and that the monies owned by the trust are utilized to pay for the taxes and upkeep of the property moving forward, and it can only be a family property. I can specify exactly what I want, and that is the only thing that can be fulfilled. So let's talk to trust real quick because it's extremely important. I get probably a call every couple weeks in regards to a situation that happens when a family member may pass away, and that another family member is wanting to sell the property to help pay for medical or something, or they just want to sell the property, and the property is not in a trust. A trust is the only thing keeping a property out of probate in the episode in which somebody untitled passes, okay? So I cannot emphasize that enough, how important it is. They can have a living will, it's still going through probate. It's a minor probate, but it's still going through probate. They could have something documented and written up. It could even be notarized. It's still going to probate. And keep in mind, when something goes to probate, most times over not, you will need a probate attorney, which then obviously costs money and it takes time. So I can't emphasize enough, even if all you did was go on to something like a LegalZoom and do a trust and have it certified and notarized, that would be better than not, okay? But I would highly suggest that if you own one property, that you have a trust. Most people think, I don't own enough, I don't need a trust. Wrong. If you own one property, you should have a trust. And in your trust, you put your property of your house, you put all your personal belongings, you put any bank accounts and stocks and bonds and mutual funds and everything else that you may have in the financial sector. You put your automobiles. I've even seen people put their pets into their trust of what they want to happen with their pets. And you can specify in there what happens. So, in my trust, we can specify that if something were to happen and the kids are under X amount of age and they're still in college, that X amount of money from X is going to pay for school, and that the houses are divided in this fashion, and the automobiles in this fashion, and our bank accounts and our mutual funds and our stocks are going to be divided in this fashion. And that's exactly what will happen in the instance in which we pass. And there is no need at that point for a court action or anything else to take place, because our trust is going to mimic and overrule anything. And so it kind of takes everything out of play. If you have multiple children, if you have a joint family, right? where there's children from both sides and it's a blended family, I can't emphasize enough why you would need a trust, okay? And when it happens, what we typically do is we close on this. Escrow draws up the paperwork to roll it from the deed in which it closes into the trust, and they get recorded simultaneously, typically the next day. So what happens is we'll close on the property. Let's just call it, it's a husband and wife, community property and rights of survivorship. And then we also record a second deed where they deed it over as community property with rights of survivorship into blank family trust. And then it's held by the trust. And then within your Schedule A list in your trust, you would have that house listed and you would have the deed listed in there, and you would specify in your trust how you would want that property handled in your absence, right? That's the only way of keeping it out of probate, period. End of story. There's no discussion on it. It's the only thing that's keeping it out of probate, okay? Now, community property rights or survivorship, if one spouse passes away, it reverts over to the other, right? However, what happens if the second spouse passes away, right? So you have to be prepared for the worst, but ultimately you can continue to add to your trust once it's done. So it's not like each time, say you want to buy multiple houses. Well, every house we buy, we add into our trust. And so you'll want to make sure that happens to protect you and your family, amongst all other things, right? And then if you do have a trust drawn up, I would recommend that you have it drawn up in a way that also encompasses a power of attorney within it. That way you don't have to have a separate thing drawn up. So if it's drawn up between husband and wife as a family trust, have your power of attorney drawn within it. So the trust will also act as that, versus having to have a power of attorney if something were to happen medically wise or physical, and then the trust in place. You can kind of have it all in one. Okay. But let's go ahead and open this up for discussion. And during that, I will post this document in the comments as well. So anybody wants to come off of mute, now would be the time to do that. And let's have an open forum in regards to title being held. What do you guys see out there from your clients? What kind of questions are being asked from your clients when it pertains to how they should do that, et cetera? How do you answer it? I think that's the biggest thing. Betsy asks, with a trust, the property is titled in the trust, correct?
Right.
You are willing it, so I would be willing it, Tommy Dutcher and Jennifer Dutcher as husband and wife as community property with rights to survivorship hereby grants to the Dutcher Family Trust, right? And then the property is in the trust name, okay? Typically, it will be Tommy and Jennifer Dutcher, husband and wife, successors of the Dutcher Family Trust, right? As you may see it on the deed as that as well. But the trust is listed in there. It then is held by the trust, not by us as an individual. It also protects us. If somebody were to come after us and try and sue us, it protects us there as well. Okay.
So it would be as an individual then, the trust would be an individual rather than community property with Tommy and Jennifer?
Yes and no, because in our trust, we have a joint trust, right? So we're both successors of our trust. Sometimes, for instance, you just got married this last year. Let's say you had a family trust yourself and he had one himself. You don't have a joint one, and you buy a property together. Mm-hmm. It can't be in this trust or this trust. It could be in both, right? But you would have to list it specifically, and then you would be listing in your trust as 50% ownership rights. He would be listing in his trust 50% ownership rights. It'd be held by both trusts, not just a single.
Okay.
Now, typically that's not the way to do it. We would recommend that you guys have a joint trust, and that any joint property is held within that, and any separate property is held within your own separate trusts, right?
Yep.
Because then 100% dictates exactly what you want to happen with your personal stuff before marriage and your joint stuff during marriage.
Right.
Yeah.
Okay, so then I guess my other question would be then, if the difference between a joint tenancy and a community property with rights of survivorship, the community property, they can sell it separately?
Okay, so community property with rights of survivorship can only be held by husband and wife or domestic partnership. Joint tenancy can be held by two individuals. It doesn't have to be husband and wife.
But why would a husband and wife do community property versus joint tenancy?
You can do both. You could, no, you can't. So let me bring it back up and explain it, right? So it's easier if I can show it to you here. So joint tenants, right, can only be held by two or more persons. It may be spouse or domestic partners. So yes, they could hold it this way. And then community property with rights to survivorship can only be held by husband and wife or domestic partners. Now, either or, it's going to revert to the other, right? But only husband and wife or domestic partners can do community property with rights to survivorship, where joint tenancy can be held by just two random individuals or more, right? They don't have to be married or domestic partners.
They're the same thing, essentially.
Yeah, essentially, yes, but not everybody can do both. Anybody can do this one, not anybody can do this one. Right. All right, so great questions. Anybody else have questions? You guys got to have questions about this because I get tons of questions. Tracy, what do you got?
I have a client or friend who is literally on his deathbed, and he doesn't have anything set up, and he's afraid that, you know, his ex-girlfriend is going to go over there and take it, and the only person that he has, I mean, is his daughter. He's afraid that his ex-wife is going to take it from his daughter, and, you know, things like that. So how quick can you get something like this done? Because
okay, so my recommendation, and I'm not giving legal advice in any way, shape, or form, so I'm just disclaiming that right now. Even if he's in the hospital, you can have an attorney come to his bedside.
Yeah, he literally is in the hospital.
Yeah. So again, an attorney can come to his bedside. An attorney can represent him. An attorney can draw his trust and do everything based on that. And more than likely, depending on his condition, they may need at that time as well, you know, some type of doctor's note or what have you, explaining his mental capacity or what have you at the time. But if he is physically coherent enough to tell a lawyer by himself without somebody helping him what he wants to happen, then that should be sufficient for a lawyer to be able to draw up a trust.
Is it possible just for him to gift it to his daughter and get a notary over there? And
no, depending on how title is being held right now, no. And then you also run into the capacity of, you know, say he says, I just want to add my daughter to title. Well, then in the capacity in which a notary is going to his bedside to do this, title would want to see stuff like doctor's notes on his mental capacity and that he's not being held against his will to do it, et cetera, et cetera. It opens up a whole nother can of worms. It sounds like he has more concerns than just, say, a house. Therefore, it would probably be best if he had, you know, a lawyer that can handle a trust and drawing that up to come to him and draw that up based on what he wants to see happen, and then have
he has 4 or 5 properties and several vehicles, boats, you know, things like that. But he's afraid that his ex-wife is going to come in and take it from his daughter because, I mean, she's actually a real estate agent, and she's actually swindled him and forged his signature on a lot of things. And so that's what he's afraid of, is that she's going to come in and swoop it and take it all, you know?
Well, I mean, again, it sounds like even more reason why an attorney needs to be involved in this. But if he doesn't have a trust, he's going to want that, because otherwise all 4 of those houses are going to probate unless they're owned with somebody else in a joint tenancy or a community property with rights to survivorship. But it doesn't sound like they are.
Right.
So he's going to want to get that done immediately. Otherwise, it's going to go through the court system. And at that point, it's going to be a plead with the judge to decide who has rights to what. And there's a possibility that the ex-wife can get stuff. There's a possibility the kids will get stuff. There's a possibility that other next of kins come forward and say that they have rights as well, and this is what he would have wanted. They have to prove that. And it basically comes up to somebody to make a decision of what's right and what feels right. And in all honesty, I don't want a judge making a decision over my livelihood that I worked hard for, and I own multiple houses and I own multiple cars. I don't want a judge deciding who gets that. I want to decide how I want it divided out, and I don't want anybody to be able to do anything other than what my wishes are. That's what a trust does. So at that point, nobody has the right to be able to take you to court and say, no, I should get this. No, the trust is here. The trust was drawn up from an attorney. The trust was notarized, and the trust stipulates X, Y, and Z to happen, and that's exactly what will happen. There's no court that can overrule that. But great questions. Any other questions? Come on, guys. Colleen, Karen, you guys have anything?
Tommy, can you hear me?
Yes.
Okay, I have a really stupid question.
Nothing stupid.
It's really dumb. But what is the actual difference then between a trust and a will if everything has to be in a trust? Then
a will does not, you cannot hold ownership rights in a will. You can hold ownership rights in a trust.
Okay.
I mean, that's the easiest way of summing it up right there. Yeah. is exactly that
but otherwise they're the same?
No, they're not the same.
Then what exactly is a trust?
A trust is a legal document outlining all your personal possessions and property, and you stipulating what you want done in it. A will is a document that also stipulates what you would want, but it doesn't have ownership rights over what you have. So therefore, if you put it in a will, it's still going to go to probate, but you have a will that's notarized from the individual, and therefore the courts will take that in consideration based on that. But it still goes through the court, so it opens up the area of people saying, no, he wasn't in or she wasn't in their mental capacity when they had this done. It just opens up a can of worms, and so to speak, in some cases, right?
Right.
But it gives them a guideline to go by of, okay, this person took time to drop a will and have it notarized. Therefore, we're taking this in consideration. But the house is not held in title in the name of a will. It's still held in the individual's name. Where when you move it into a trust, it's held by the trust. And the trust then dictates what will happen with your personal possessions.
So will is kind of just like a desire, what you desire to happen.
Yeah, a living will is a wasted document.
I never knew that. Okay.
Yeah.
Well, that's my main question.
Yep. Great question, though. What else you guys got? Come on, Marie, what do you got, girl? Nothing? All right, well, go ahead.
Sorry, one thing I do want to add, because I've had this several times, is when you refinance a property, often you'll take it out of the trust to refinance. So for example, if I refinance my place, it'll be under Betsy Berkey. And then once I'm done refinancing, then I have to put it back in the trust right away. If I die in between that refinance, when I took it out and put it back in, then we got a problem, a big problem.
So let's talk to that. You are 100% correct, because a trust The refinance is done from the individual, right? So Betsy has a property, it's held by the trust. She decides she wants to refinance, take advantage of these 2.5% interest rates. So in the process of doing that, it's pulled out of the trust to refinance. And at the time that she signs the documentation for her refinance and everything, she's going to sign another new deed, transferring it back into the trust. As soon as that deed's notarized, it's an active deed. It doesn't have to be recorded, okay? So remember that. Once a deed is signed, does not have to be recorded for it to be a legal document of transfer of ownership. Recording it protects you, because if you lose that document, you have no ownership rights to it at that point. You don't have the document showing you do. And the last recorded deed was the last person on title. So let's say I sign a property over to Betsy. I quit claim a property. I quit claim it to Betsy. We go down, we get it notarized. I have relinquished my rights from that property, okay? But Betsy doesn't go down and record it. And then all of a sudden, Betsy puts it in her car. She gets in an accident, and the car burns down, and it burns that deed. Who owns the property? Technically, I do, because I'm the last one with the recorded deed on that property, and the one that I signed over got burned. So it was never solidified in any way, shape, or form. She would have to be able to prove it. Well, her proof is the signature on the notarization of that deed. So that's why you have things recorded with the county right away through title, is because it protects you and it transfers it to you, right? So again, when that happens, as long as Betsy were to have signed it over to the trust and something happens to her and that transaction stops, it's still in trust name at that point. It just, it hadn't been 100% pulled out of it to begin with. It's done in the transaction. The transaction never took place. But if it did take place and it was on the day of, she's already signed that document. Somebody has that document to show that it's in the trust name. That's all that matters. But great questions, yes. The other thing is, in the presence of somebody passing away, we've seen incidences where somebody, let's say somebody is a wealthy individual. They own quite a few properties, and in their trust, they dictate that these properties are paid in full, and they revert, say, a bank account or a financial account over to be owned by the trust. So therefore, there's funds that the trust owns, and they say they can never be sold, right? They can never be sold, but the management company that's in place will continue to manage it, and this will take place, and that will take place, and the monthly expenses will take place, but the money that's made off the rentals and stuff gets divided 4 ways across 4 kids, right? But the kids have no rights to ever sell the property because the trust owns it and dictates it cannot be sold, okay? It can be passed down in generations. A lot of times you see that where, you know, my father has a trust as it can't be sold, but I have rights to the income that comes from it. And in my passing, my daughter will have those rights. But it will stay as a family house owned by the trust forever, right? And then you have somebody who manages the trust. Usually when that happens, they put a company involved to manage the trust, not necessarily an individual. So, you know, a trust can continue to own the property ongoing after somebody passed away if that's what they want to happen, okay? What else? Any other questions on tenant?
What qualifies as a domestic partnership? Is it still like the whole how many years together, blah, blah, blah?
Yeah, I mean, ultimately, I guess the easiest way to sum it up is if you're to a point where you can prove that you guys share all financial liability, you report taxes together and everything else, you're a domestic partnership.
Oh, okay.
What else? These are all great questions, though. Okay, I put the document in the chat notes. So if you guys click on chat, you'll be able to see the document, the PDF there. I would recommend that you download that and keep it because it's a great cheat sheet for you to have. Store it in your Google Drive or something so you have access to it at all times from your phone. And you can rename it. For some reason, Annie had it named Standard Buyer Opening Packet, but ultimately it is, I would rename it Ways of Holding Title. But yeah, we get these questions a lot. I get more of the questions of like, hey, what can be done? I have a situation where I have a client and the client's in this situation and title's being held this way. And I can tell you 9 times out of 10, it's never a good outcome response that they're going to get because of how title is being held doesn't allow it. And a lot of times it comes down to explaining what they need to do and giving them the next person to get advice from. And typically it's a lawyer. So I can't emphasize, I just had arguments with my parents, and I say arguments in a good way. This wasn't a screaming thing. It was, you need to do this because I don't want to deal with it after the fact, right? And that was, you need to get a trust. And my dad was like, I have a will. The will states this, blah, 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 we're good. And I'm like, no, because jointly as 3 children, we don't want to deal with the courts. We don't want to deal with the courts with your bank accounts. We don't want to deal with the courts of paying your bills during the process. We don't want to deal with the courts of what's going to happen with the property and whether or not we can sell it or keep it or what have you. And the trust is the only thing that's going to dictate that. The will does nothing. We would still have to pay for a probate attorney and go through the process of 8 to 18 months of trying to get it situated to where we have rights to it. And I'm like, I'm telling you right now, both houses that you own, we will let go before we will pay for a probate attorney. It's just not worth the headache in some cases. And so, I can't emphasize enough that a trust is needed. If you could give advice to any of your clients that you sell a house to, any of them, I would recommend that you give them advice, especially first-time home buyers, because usually they're the ones that have absolutely no clue. So going through the process for the first time. You want to leave them with some good, helpful advice? Doesn't matter how young they are. Develop a trust, just so you and your family are protected. That's the best advice I can say you can give them. Because I see the ugly side of it when there's not a trust involved, and what families have to go through during things that may happen and what they have to go through, the process they have to go through, and the financial burden that they have to go through to deal with real property once somebody does pass. And that's one thing that we don't do as a society is we don't usually plan for that, unfortunately. So I would say that would be, in my opinion, the best advice you can give somebody after you sell them a home is exactly that. So we can have an entire Zoom and Learn on just trusts, and we may do that. I may bring on a trust attorney here in the next couple weeks just to discuss trusts more in depth, like really the core of a trust, step by step, line by line through a trust of what really needs to be done, because I get a lot of questions in regards to it. And a trust is only as good as it's written. And I say that vaguely because I can't tell you how many times, I call the title unit with a question. I say, yeah, it's in a trust. They say, we need to see the trust, see how it's written. And sometimes it comes down to, somebody is incapacitated medical-wise or health-wise, or something happened unexpectedly, and it comes down to how a trust is written on what the rights of the other individual has, et cetera. So it's extremely important, and I think we can probably have an entire Zoom specifically on that. I think we will. All right. Any other questions? No? Some good questions so far. Both my parents recently told me they will. Okay, so there was a question that came through that said, both my parents have recently told me they did their will, but now I'm going to ask if they have a trust. Multiple properties involved, divorce, et cetera, remarried, et cetera, et cetera. Yes. Yes, make sure they have a trust. The will is a great starting point. It does give guidance, but again, it does not keep a property out of probate at all. So please check and see if they have a trust. If they don't, I would highly recommend that that's the route that they go, especially with multiple properties. And it looks like divorced and remarried, so they probably own things separately as well as jointly. A trust would definitely be needed in that type of situation. Great questions today. All right, well, cool. I appreciate you guys all coming on. We're going to do this every Wednesday at 12:30. It's going to be a different topic each week. And a lot of the topics, again, come from the questions that Annie and I get asked throughout the weeks, or they get suggested to us. Yesterday, Annie and I were tossing around. We're like, oh my gosh, what are we going to do tomorrow? Because we hadn't even thought about it. Normally we know, by Friday, and got to a point where Annie's like, I'm drawing a blank. I can't come up with anything. And I'm like, you know what? I literally got a question an hour prior in regards to the difference between joint tenants and tenants in common. And I was like, we're going to do it on the different ways of holding title. So if you have suggestions, please throw them out there. If there's things that you still as an agent question when they come up, throw them out there and we will make it a Zoom and go through it all. Yeah, that's basically what we're trying to do is take the feedback from you guys so that we can give you value each week. So with that said, I hope that you'll join us next week at 12:30. And again, I will try and schedule one over the next 2 weeks with one of the trust attorneys that I know in regards to going over the trust in general, because I think it's extremely important for people to hear it from a legal perspective of why it's so important. I can sit here and preach to you all day, but they can give you specific examples of what their clients had to go through when they didn't have it in place. So, all right, guys. Well, hey, thank you very much. I appreciate you all.
Thank you.
And thank you all.
Thanks, Tommy.
Thank you. Bye.
Thank you, Tommy.
Thank you, Tommy. Happy birthday.
Happy
Oh,
birthday.
thank you.
Happy birthday.
Have a
Thank
great
you.
day.
Birthday.
Happy
Feliz
birthday.
cumpleaños.